Hi everyone, selamat datang semuanya. Thank you for coming. This panel, as you probably well know, is Indonesia Law and Justice Programs, Sustainability, Inclusion and Effectiveness. And we have a lineup of pretty superb experts that you're going to hear from. I myself am not a law and justice expert, so I just have the great privilege of showcasing the expertise of these guys. My name is Mira Sulistiyanto. I'm an analyst at the Development Intelligence Lab. I think I'll introduce everyone in full ahead of them speaking, but just for context, we've got at the table here with me Desi, Arsa, and Marsha. Sorry, God. Marsha and Arsa. And then online you'll hear from Mas Dio and Mbak Gladys, who I'm reliably informed are with us. You just can't see them right now. You're on the screen, Dio and Gladys. Give a quick wave to the audience.
And hello, everyone.
Wonderful. I think let's kick off. To start, we have Mbak Desi Yunitasari, who's a postgraduate at Melbourne Law School. Thank you for making the trip to Canberra. Speaking to gender, law and development aid, women's rights and legal challenges in Indonesia. And I have a mic for you. Take it away.
Thank you so much for giving me opportunity to be a presenter here today. Good afternoon, everyone. My name is Desi Yunitasari. Next slide, please. Yeah, next slide. Okay. I'm actually presenting with my sister, Devi Yusvitasari, but unfortunately she couldn't join us today due to some health reasons. And I'm going to present our research titled Gender, Legal Aid and Women's Rights in Indonesia and Development Aid that focusing on women's rights and legal challenge. And the background is, the first time is about the Indonesia's legal environment is multi-layered, not a single system. And international development assistance has been increasingly prioritized gender equality in Indonesia. For example, donors such as UN Women, UNICEF, or even UNFPA have a lot of programs related to gender-based violence, especially in child marriage prevention, domestic and sexual violence reform, and women's participation in public life. For example, the program is about UNICEF and UNFPA co-implemented Berani program, our Better Sexual and Reproductive Health and Rights for all Indonesia, aimed at reducing child marriage, GBV, or even FGM. However, the outcomes are highly shaped by the Indonesia's plural legal system and local moral authorities. Next slide, please. So our research focused on how does the development aid interact with Indonesia's plural legal system to shape the gender justice outcome. So we are less focused on aid volume or budget, but we focus more on how law and aid meet in everyday legal practice. Next slide. Okay, the thesis has 3 main points. The first one is donor-supported reforms have enabled important normative progress, as we put in a slide. And then second, the transformative impact is limited by, like the first one is overlapping state, religious, customary laws, patriarchal norms that has embedded in society, and the third one is about gender justice depend on law is interpreted, especially at the local level. Next slide. And Indonesia has the plural legal order, such as adat law, for example, Bali mediasi, Kalosara in Sulawesi, and other local customary codes. And the second one is about Islamic law that, for example, that has been implemented in Aceh. And then the other one is the state law that actually has transformative law related to gender-based violence, for example, sexual violence crime, law or criminal code and Supreme Court regulations. And then the last one is about moral norms that still highly implemented in society. Next slide. So the theoretical framework we draw from the feminist legal theory and legal pluralism that say how we treat law is not only about how law is shaped by the state itself, but how it reflects the society, especially the cultural society, and it reflects the power relation, not neutrality. And so legislative change, especially related to gender equality, is not really reflected by the lived equality itself. So the legal pluralism is about the multiple authorities define what law is, such as how the law is defined by the local actors, and then the community expectation of often override the rights of women. Next slide. So this is an example, such as the marriage law amendment that has been supported by the donors. For example, the marriage law amendment in 2019, the minimum marriage age for girls raised from 16 to 19. This is also triggered by the Constitutional Court decision, supported by the donors, and show the effective donor-civil society synergy within the existing political momentum. The next slide. This is the second example of the donor program itself that has been successful in implementing supporting the ratification of sexual violence crimes law. For example, this TPKS law in 2022 that implemented by the government, that also supported by UN agencies and civil society, that introduced 9 categories of sexual violence, integrated survivor services and restitution. Next slide. This is why the legal reform is not enough, because law enforcement often just prefer familiar criminal code provision or KUHP, and code often apply formal law through culturally informed discretion. And so this also reflects the persistent moral norms. For example, the sexual violence law itself is the implementation is uneven in local area, and then the limited local service as well also influence the implementation. This is what more fragmented coordination among the ministries and local government. Next slide. So the case studies, for example, in Aceh, such as Konun Jinayat, or like the regulation that should prevent women from having the relationship with the non-mahram, or when they are not married, they should be prohibited from having like relationship, or Kanun Banda Aceh that enforced by the local actors. So the gender impact from this regulation is like women more frequently targeted in moral inspection. So there's crowd enforcement as well that affects mobility of women, and the donor empowerment programs reframe through moral language, not the rights of women itself. Next slide. This is the second example of the how law is actually being implemented in the local area. For example, the regulation, the provincial regulation number 9 of 2018, that customary institution can dilute statutory protection. And this is the regulation is often implemented in domestic violence cases, such as they should have the mediation first, rather than just process through the law, especially national law. And the priority placed on family harmony rather than just survivor protection. Next. So this is another example in South Sulawesi, or we call it Kalosara. That there is a ritual-based dispute resolution that prioritize the conflict often treated as the extended kin groups rather than just individuals. So the local actors often prioritize harmony rather than punishing or implementing the regulation, especially national regulations such as sexual violence law and criminal code. So even though Indonesia has national laws, the community is relying on kalosara that few adat solution or customary solution as more legitimate rather than a national law. Next slide, please. Yeah, this is also another example, such as marriage dispensation, that in practice still uneven in society because judges often grant the marriage dispensation due to some moral reasons, such as to prevent from unintended pregnancy. Next slide. Next slide. So this is the regulation that often has the contradiction factors such as the religious code or Perma or of Perma number 1 of 2016 that the mandatory code meditation is often implemented in the cases such as domestic violence cases, and this also applies even these cases involving allegation of violence. So the survivor even show unsatisfaction about the result of the cases itself. And then restorative justice is often implemented in the sexual violence cases. So this is also based on the National Commission on Violence Against Women result of the study that the widespread use of widespread use of restorative justice is often implemented in gender-based violence cases. And so the customary settlement preferred in many regions, especially in customary regions. So the risk is the lack of accountability, re-traumatization for survivor as well. Next slide. So why the donor influence is limited here? Because the program of the donors itself is often about the how law is being implemented, but it does not reflect how the society in how the local norms has been embedded in society. So these the factors such as the patriarchal culture that I have said before, that for example the sexual violence law that has been ratified by the government, but the implementation is still heavily depend on the local actors, for example the customary actors and other sectors. Next slide. So based on the Sally-Engelmary concept, international human rights norms including gender equality and the protection from violence do not actually enter the local society in pure form because they are translated, they are adapted and reinterpreted to fit the local moral frameworks and power structures. So in Indonesia, if norms are not translated into the local norms, if international norms are not translated into the local language, so the society often call it like Western values. It doesn't reflect the society, so it makes the donors program itself does not have the effect of the in the society. So the global norm must be translated into local values. So without translated norm are often seen as foreign rejected or interpreted conservatively. And then this is also an example that I have said before, such as the moral guidance in Aceh. Next slide. So the effective strategies include how the community dialogue grounded in local culture. The second one is about the hybrid justice model. For example, the harmony concept that has been implemented by the local actors should be less implemented before the law itself being processed. So the third one is about embedding legal reforms within broader structural change and ensuring survivor-centered, not just perpetrator-centered. Co-design judicial training with feminist organization and case tracking system to monitor diversion mediation and long-term funding for men's group. slide. And then key takeaways are the Indonesia's plural legal system shared the outcomes, even though the donors has been trying to always make reformation, especially in gender equality. So the donor influence is strongest at the normative level, not also in the implementation level, because in the implementation itself depends heavily on interpretation, discretion, and community expectation. And the gender justice requires engagement, not just legislation. So the law, this reflects the law function, but both as empowering and constraint. Next slide. The conclusion is true gender justice requires more than legal reform because it requires transforming the social, cultural, institutional condition in which law lives. Thank you.
Thank you so much, Desi. We're going to save questions to the end to make sure that we have time to get through all the presentations. But if you have questions specifically for Desi, then I encourage you to just note them down. We can come back to them. But I'll move now to, we're going to hear from Marsha Maharani, who's a researcher and program manager for Desi at the Indonesia Judicial Research Society. Marsha's work has a particular focus on women and children's issues, particularly gender-based violence and child marriage. Take it away.
Okay, hello, good afternoon, everyone. I'm Ashar, and today's my presentation will be talking about how Indonesia's justice system advances gender justice through strategic international aid. And maybe the particular focus for my presentation will be the challenges and what we can do more after this. Okay, next. Okay, so through my work at the Indonesia Judicial Research Society, I've had the chance to look closely at how survivors of gender-based violence experience the Indonesian justice system, and where it still leaves them behind. Like there's still like shortcomings for the victims, because survivors and victims don't just carry the trauma of the violence itself, but they also face stigma and financial loss. And many of these women have to cover the cost of their own recovery, such as medical care, counseling, therapy, and even that we have the laws on restitution or compensation for the damages that they suffered. The regulation technically allows it. We still lack the access to get the access to the restitution. And when these women do step into the justice system, they often meet with victim blaming, biases, or even treatments that are not particularly good, which often makes them quit the legal process. And these problems are things that we found in our researches and how it affects, particularly affects how like the Supreme Court and even the Attorney General office conduct its practice when they are handling cases. And as we know, that the violence, especially violence towards women, keeps evolving. Like we do not just see like physical violence, but we also like see like violence in the online sphere. And what we see now is that the Indonesian system and the policy needs to expand beyond that if we want to truly get into the gender justice system itself. So I would say like the reforms are underway in Indonesia, but it is still uneven. And Indonesia does not yet have like strong prevention policies or victim-oriented alternatives that could stop violence before it escalates or give survivors easier ways to reclaim their rights, particularly when they face this physical or even online violence. And the gap that I want to emphasize is that we have ongoing progressive regulations on paper, but without stronger institutional commitment and policy innovation, survivors remain excluded from fair justice system and a meaningful recovery. Okay, next. And if I look at what has been achieved so far, international aid in Indonesia has played a really important role. So I would like to speak about my experience with the Australia-Indonesia Partnership for Justice, in which the Australian support help reforms inside key institutions, particularly the Supreme Court and the Attorney General's office. So we have like the key actors are like judges and the prosecutors. And we moved beyond the internal practice on each institutions into national legislation. So I would like to take the example of the Supreme Court Regulation number 3 of year 27 and the Attorney General Guidelines number 1 and year 2021. These two regulations place about like the code of conduct in which judges and prosecutors have to act when they're facing the victims, particularly women in conflict with the law. So the main issue that's being told in these internal regulations that we are making access to restitution easier, like we are telling them like it's possible to access restitution and that it is mandated by the internal regulations that judges and prosecutors have to inform the victims, they have to let the victims know about their rights, such as like access to legal aid, access to victim support, and also like whether they are want to file for restitution. Because in India, as research, we have found like in our research in 2019 to 2022, from many cases that we indexed, is that only 1% of victims file for restitution. And that is a very small amount of people who got that. So we see the problem is that how are they getting compensated for that? And we also see like the progress within the regulations that especially on the prosecutors that if the victim is a child, then it is mandated by law that prosecutor is responsible to arrange the restitution process on their behalf. So we are seeing internal regulations that strengthens the national law itself. And that we also see that these both regulations share a clear gender justice focus. They prohibit victim blaming and guarantee women in conflict with the law for further help on recovery. And what I want to note is that IGRS or my office, we were directly involved in this process because we were part of the working group in these two institutions. So we conducted in the research and contributing to drafting these regulations. And this experience showed us how aid partnerships can create a space for civil society expertise to shape institutional regulations. And then what we see next is that in 2022, the law on sexual violence crimes took those principles in the internal regulations from the Supreme Court and the prosecutors, how to embed it in the national legislation. So what we see is that the progress that's happening is bottom up. We see from the internal regulations and then it was uplifted to national law. And we make them binding across the justice system. So it also shows how like 8 different reforms at the institutional level can grow into systemic reform too. So also from my perspective is that this is a very clear example of how strategic partnership can move reforms from practice into policy, and that from that good policy, it turns into a stronger law. So it's also a proof that this aid can be made a catalyst for change, and that also a reminder that laws alone don't guarantee justice unless institutions consistently implement them and victims are supported through clear, accessible pathways. Okay, next. So now what we're seeing is that what happens after that we have such great policy infrastructure that's been provided from the aid support. We see that commitment they show in lawmaking, but Indonesia continues to pass and update progressive frameworks. But this practice also requires more than drafting rules. Like it needs serious planning, budgeting, and quality control training to see whether these policies are working or not. So in reality, that what we find is that regulations are applied unevenly, like it is something that exists on paper, but enforcement in daily practice could be inconsistent. Judges and prosecutors may know the standards, but without monitoring and accountability, personal bias still shapes the outcomes. Because we also see cases where like many of these judges and prosecutors sometimes blames the victims because they have like personal conviction that, oh, maybe your lifestyle makes people treat you badly, things like that. So we also see that But the internal regulations state that you cannot do that, but still personal biases sometimes get in the way. And also that another weak point is about the national training, because we do not have like a national quota that is consistent and applied consistently, and leaving some regions covered while others are not. It could be said that maybe regions that are rural might be neglected by the institutions because they do not have enough budget to cover that. And urban areas tend to benefit more, while the rural areas, as I said, lack access to this training. And this uneven distribution means victims in rural contexts are at greater risk of exclusion. And we also cannot separate the reform in Indonesia with the champions that we can see in judges and prosecutors. And this momentum of reform depends to these champions, because these people are what we identify as prosecutors and judges who have great perspective, and that they have the commitment to make their institutions better. I would say that these people also was part of the working group that was working on the past two regulations that I mentioned on the slide before. And these champions are also people who are involved in the trainings too. But we face problems when these champions are transferred or when they retire. And progress might slow because of it. And sometimes the other problem that comes that if they have successors who have like perspectives that are not as good as them, or maybe they resist the victim-sensitive perspectives. So there is also an interest in renewing regulations from the Attorney General Office and the Supreme Court. And I would say that after the sexual violence crimes law was passed in 2022, they also expressed the need to update the regulations that was passed in 2017 and 2021. I would say that they are quite responsive to that, but it can be said that their focus for now is still leans more toward rulemaking than toward ensuring consistent practice, planning, and quality control. So they're more obsessed with the laws, but not with the planning and budgeting itself. So that is what I could describe as the core challenge. Like the Indonesia's justice reform has a potential for progressive policy infrastructure, but without deeper institutional commitment, such as to budgeting, training, and monitoring for these practices. These good policies are still they are still at risk as like symbolic reform rather than transformative justice for the victims. Okay, next slide. And my reflection from the past three slides is that institutional commitment often stops at the level of regulation. And the next question is that what can we ensure to make sure that the progressive policy infrastructure for gender justice truly works for the victim? And the answer lies into areas such as prevention and victim-oriented innovations. Prevention means building systems that stop harm before it happens, through education, public awareness, and internal safeguards that make justice actors more gender-sensitive and victim-focused. This cannot be an one-off effort. It requires a regular training with quality control so that victim-sensitive practice becomes embedded across the justice system. And also a clear example of the gap in prevention is that protection orders. Maybe it is often referred to as restraining order. Indonesia has recognized this system since the Domestic Violence Act back in 24, but to this day the implementing regulations have not been issued. As a result, the concept remains very narrow, and often when we interview police officers and judges, is that this practice are not done yet in Indonesia, even though the law said that it can be done. And also we have shortcomings in terms of how the law defines like partner, that only refers to someone who is legally married. But if we see statistics, it's that many violence in Indonesia towards women are done by ex-partners, whether it was their husband or maybe ex-boyfriend, but that is not bounded by marriage. And we see that as a gap in the law that gives exclusion to the victims. And in Indonesia that the protection orders are also issued after the criminal act has happened. So making it more like a response mechanism instead of a preventive safeguard. And also that victim survivors also have justice needs that criminal processes alone often fail to meet, such as like victims wants to be involved in the cases, they want to have a voice, want to see their experiences acknowledged, and they want to not be blamed and know that the offenders are held accountable. But meeting these needs require innovation beyond prosecution, which approaches that put victims at the center and ensure they feel heard and protected. And also that to complete things is that we also see a rise of non-consensual intimate image, and this is very urgent because in Indonesia we do not have like a mechanism that we can rely on, because survivors face stigma and complex procedures to remove harmful content by and monitoring from legal aid organizations and community-based providers. They found that the ministry-led services are often non-transparent, like if you want your content removed, we do not know whether it is being prioritized and what is the variable for that. And they also because also like in Indonesian law, when it comes to removing those online content, the sexual violence online content, the ministry frequently classified it as pornography, which trivialized the harm and shift blame on the victims. And because what survivors need is a clear victim-centered pathway, one that treats these kind of crimes as a crime and violence, not obscenity, and ensures timely removal to a genuine right to be forgotten. And all of these pathways requires a research before policy without evidence-based analysis and contextual adaptation to Indonesia's legal, social, and cultural realities. Reforms is to seen as symbolic or misaligned with victims' needs. And this is why we need the research to ensure that innovations, whether expanding protection orders, addressing NCII, or designing victim-centered service, respond to the experience and strengthen access to justice. So in the end, I would say that the approach to the gender justice is very broad, and that we have to move beyond the cases of the victims itself, but we also move forward in terms of prevention and seeking innovation in which we have to do to help the victims. Thank you.
Thank you, Marsha. Next, we'll hear from Arsa Budiarti, who's a postgraduate at University of Melbourne, also a senior researcher, but previously director of Indonesia Judicial Research Society.
Thank you, Mira, for the introduction. Good afternoon, everyone. I hope everyone's still awake this very last session. So my name is Arsa. I'm from IJRS as well, currently studying in University of Melbourne in social policy. And I'd like to share our experience that highlighting the role of international aid in Indonesia, especially in encouraging the people-centered in the policy evaluation in the justice sector. So I'm supposed to deliver this presentation with my other colleagues, Marcel and Muhammad, but they will not join us today. But I'd like to make a little disclaimer that we were coming from civil society organizations. So our presentations are going to be based on our experience in developing two major indices in legal sector, which are access to justice and legal development index. So these are two major indices that we work together with the governments. We work together with development partners in Indonesia. So we kind of saw some potential in enhancing the collaboration between the donors, the development partners, and also the government, and also the CSO. So the presentation will be all about the experience in evaluating the justice programs in Indonesia. And I'd like to give out more context as well about that. I think most of you already know that in early 2000s, all of the development agenda anchored their planning into the MDGs. That after 15 years of the effort, I think it's been reported that MDGs has been too ambitious, too donor-driven, too top-down, and lacking meaningful outcome in the implementation. And then next slide. Following up on the gaps of the MDGs, as we all know, the new shared agreements in SDGs then developed in 2015. We have this new whole of shared agreement, again ambitious goals to be followed up, but we kind of saw that there is a shift in the approach between the MDGs and SDGs. The SDGs has try to focus more on the localization, more on the community-based approach, people-centered, and putting more focus into marginalized and vulnerable groups. Those kind of shift, those kind of approach that SDGs are trying to take into the whole goal is a very good intention, I could say, because it's kind of transformative from the MDGs. But however, after let's say almost 15 years, 5 years to the deadline on 2030, we kind of see that these good intentions are not met its goal because there's a lot of technical implementation that are like misses the value of the community itself, misses the perspective of the community itself, understanding the needs of the community itself. It's kind of like being neglected into the planning and into the development agenda process itself. So next slide. We kind of identify the root causes on why is it difficult to the development agenda to adapt the people-centered justice, the people-centered approach properly. First is because there's a lack of quality research in the planning process, which if you are familiar with the garbage in, garbage out, if you it's difficult for us to get good outcome if the planning process didn't prepared like properly. So this kind of thing happen in Indonesia as well, and there's a lot of meaningless local participation as well, such as like just formality participation, formality forums that are being conducted by the government to justify that we've done this participation with the local community who are affected by the programs, and that's exacerbated by the limited monitoring and also evaluations that are very shallow, and again formality purposes as well. Next slide. And all of this context, why I said it in the beginning, it's because it's reflected in the justice agenda, justice reform agenda in Indonesia. As you can see, during the MDGs era, the focus has been like the rule of law focus, enhancing the capacity of institutions, ensuring the harmonization of the law. But again, after the SDGs, the approach has shifted into more expanding access to justice, empowerment effort, and then focusing on the evidence-based research, policy reform, those kind of thing. Next slide. And this also being reflected in the programs or projects implemented in Indonesia in justice reform agenda. It's focusing on during MDGs, it's focusing on the anti-corruptions. And then several enhancing the capacity, enhancement agenda of the institutional capacity. And then again, rule of law approach, law harmonization, like the regulation is like above everything rather than the community approach and all. But then after SDGs, it's kind of changed toward more like access to justice, people-centered approach, and then more into alternative resolution of legal problems. If you ever heard, restorative justice is very, very popular in Indonesia in around 5 years ago. The justice reform agenda has been focused on that alone in like 5 years. We are trying to put more effort into understanding what works best in the community. So the programs like restorative justice enhancement, the empowerment to the vulnerable groups, women, children, it's become a main agenda in like 5 years ago. Next slide. And although the approach has shifted from the rule of law approach and then to access to justice, people-centered approach, you can see that earlier the programs, the area has been very lacking of evaluation and monitoring programs. It's always like program like implementing certain law, developing certain regulations, or and trainings into legal enforcers, those kind of things. But the evaluation, the monitoring effort has not been there. The program to the projects to monitor and evaluate is just very difficult for us CSOs to get the donors to want to fund us on the monitoring and evaluation, because the focus is not there. The focus is always the product of the policy itself, the regulations, the trainings. You can see the forum with full of people do the trainings, but the monitoring and evaluation is kind of very challenging for us, the CSOs, to get the fund from. Next slide. Therefore, in 2019, we're kind of trying a new thing. IGRS works together with the government, with GFAT as well, with IDLO, and also other CSOs as well in the consortium coalitions in Indonesia. We are trying to create an evaluation tools, an evaluations measurement called Access to Justice Index. Actually, this index came from the questions that we got from the higher ups in the government that are actually talking to us that, how do you think our access to justice is? How is the achievement of our access to justice? Can we say that our access to justice in Indonesia is improving or not? And at that time, we cannot answer any of that because we don't have the references, we don't have the research, we don't have any information that can correctly answer those questions. So we try to develop these evaluation tools. We try to consult with a lot of experts all over the world and also conduct like public consultation, community piloting, and around 2 years of development of these tools. And it's already conducted twice since 2019 and 2021. Next slide. This Access to Justice Index is trying to again move forward from the rule of law approach. We are not going to see whether the law, what kind of law already developed or how many laws already enacted in Indonesia, but we are trying to see how is the government records on the legal frameworks, like the development, the local participation of the policy making itself. And we kind of gather insights as well from the experts' judgment to understand the condition of legal aid, whether is it enough, is it having the best quality that we can, and the quality of other justice services. We gather those from government's record, expert judgment, and the new thing that we are trying to emphasize in this index is that we conducted surveys on justice seekers in Indonesia, people who are dealing with legal problems. We try to ask them, how is your experience? Is it easy for you to ask for legal aid? Is it easy for you to go to the court? Do you have the transportation to go there? This kind of thing. This is very new. All of the findings from Access to Justice was a lot at that time, very surprising for not only us as the civil society organization, but also for the government. Like they couldn't believe what they found in the Access to Justice Index, because we never did this to gather this kind of data, this kind of research. It's very overwhelming, but again, it's a new start because next. some of the key findings, I'd like to highlight some that make the government very surprised about the finding is that they just knew that all of the law, all of the regulations are actually overlapped. Like in Indonesia, we regulate everything. So it's basically over-regulated legal framework. They just knew about this. So the second thing is that they just knew as well, we just know that people tend to prefer the informal mechanism like under the table agreement to solve legal problems, like most of them. And yet we kept asking for money for the government, for the funders to fund the formal mechanism. But that just doesn't make sense at that time. So another findings is that we have almost 700 legal aid organizations, but and yet it's not enough. It's very unevenly distributed in the rural area, and then there's a lot of findings that shows that actually a lot of justice seekers don't actually have the capability to undergo the legal process in the first place. They don't have the knowledge, they don't have the resources, they don't have the even the willingness to enter the legal processes. It's very insightful finding at that time, because we've been so focused on the institution, we've been so focused on the police, the transformation of the police, but we forgot who are the justice seeker, who are the people who are affected by the justice system itself. Next. And actually the Access to Justice Index, the overwhelming findings actually inspired this development of Legal Development Index. So we try to reconstruct. Originally Legal Development Index has been measured by government's record, like they collect the data from the provincial level, the administrative data from the government to measure their own performance, which is quite questionable, because how you measure yourself in your own records. So yeah, we are trying to adopt those three methods from Access to Justice Index. We are not only collecting the government records, but we also conduct expert judgment, also surveys as well to the community to assess whether the current policies, the current process from the government, the current effort from the government already serve you better, already give the needs that you really need, and answering the problems that are prevalent in your community. So the Legal Development Index then has been conducted annually since 2020 with the new method. Next slide. These are the frameworks of the Legal Development Index, different from Access to Justice, who are measuring the level of people, to what extent the people are able to access the justice that they need. The Legal Development Index is more like to what extent the efforts of the governments already serve the community on its purposes. So we try to conduct like a lot of assessment, a lot of experts consultation on how to measure fair trial, how to measure whether the government already complied with the human rights principle. It's very abstract, it's very broad. So it's very hard thing to do, to measure this kind of abstract thing. But again, we never did this before. So this is become a lot of, we learn a lot from this. This become a lot of like references for other measurement, other evaluation method as well in the government works. And next. These are several key findings from the Legal Development Index, quite different from Access to Justice in terms of we try to capture to what extent the justice seekers actually understand what are the policies that are being developed. We kept saying, it's a successful achievement to finally enacted a legal aid law. But do the justice seekers even understand it? Like more than 40% don't even understand it. More than 70% only understand a little bit of it. So we are trying to assess the government's work with this index. And the most most challenging thing that we found on the findings of the Legal Development Index is that the legal enforcement issue is kind of it's the most challenging thing, because as you see from the previous findings from the Access to Justice Index, that the regulation are over regulated, right? Overlapping in every aspect. So it's hard for the police, for the prosecutors, for the judges to implement the law, because it's just like which law are we going to use? How do we interpret it with one person to each person? It's just different. So this problem is kind of like being like vicious cycle, I could say, because the policy itself is not clear. The policy itself is oftenly misinterpreted, and the enforcement itself is then being unclear as well. So this was found in the Legal Development Index. Next, and this was already mentioned by Marsha earlier, that the development on these two indices kind of like make sure that the government, giving the government a perspective on how important is it to evaluate things, because again, they never know what are the result of the evaluation. They always think the evaluation is kind of like, you evaluate us and you will give bad judgment on us. That's always the perspective of the government. But with these two indices, we kind of give them insights on what actually happened in those areas that you never visited, those areas that you never even heard of. So it's kind of inspired the other evaluation in very specific policies targeting women and children as well. And next. I think this is the last slide, but I'd like to highlight that we were very lucky to have champions in the government, champions in the development partners in Indonesia. They are making the space for us to be able to map out the whole plan, the long-term plan of the justice reform agenda in Indonesia. We were very, I could say that it's very privileged for us, IGRS, to be able to talk with the government that this thing is the one that you need to do, the one that you need to prioritize, with the support of the research. And also we also understand that to put the people-centered approach into the project management cycle, I understand it very well that it's very hard working, and it took a long time to do the evaluation. I understand it very well. A lot of, I kind of more understanding that a lot of donors and funders don't want to fund the program's evaluation and monitoring program, because it took a long time, very long time, 2 years for the Access to Justice Index, and like 3 years, I think, for the Legal Development Index, and you can only see the result after that. So it's kind of a long way to go, but I kind of see that it's an investment, because with this data, with these indices, with this information, actually I could say that most of current national development planning in the justice reform agenda has been based on the research, has been based of these two indices. Even though there's a lot of still challenge on the implementation, is another problem, but to have the correct way to plan the national development, the national justice reform agenda itself, I kind of think that it's a start. It's a start for something good for our future of the justice system in Indonesia. So again, the role of international aid in ensuring people-centered approach in policy evaluation is not going to be enough for like a year, or even, let's say, 3 months. I have fun for you for 3 months program, evaluate the policy. It's not going to be possible, but we have to understand that a good things takes a while. So yeah, that's I think our very key lesson that we learned, the very hard work that we do is actually very useful to shape the future of justice reform agenda in Indonesia. That's all. Thank you.
Thank you very much, Arsa. So finally, we'll hear from Dio Wicaksana and Gladys Nadya Arianto. Dio is a PhD candidate at the School of Regulation and Global Governance here at ANU, and Gladys is a researcher also at the Indonesia Judicial Research Society. They're joining us online.
Okay. Okay. Good afternoon, everyone at the site. Thank you to Mbak Mira and the organizing committee for the Australian Aid Conference 2025 for giving us the opportunity to share this conference. Warm greetings from Indonesia. My name is Gladys, a researcher from IGRS, and I will be presenting together with my colleague Ashar, a doctoral student at the Australian National University. And we will attempt to discuss what the cost of justice approach is and how this approach can be used as an analytical and advocacy tools to expand access to justice. And we will also highlight some findings and the strategic role of international development partners in supporting this approach for evidence-based legal reform. And we hope that this presentation provide a fresh perspective on the justice sector. So let's start to background and problem statement. As you know, access to justice in Indonesia remains uneven as evidenced by the 2021 Access to Justice Index in Indonesia, which scored only 51.4 and categorized as sufficient. This situation is exacerbated by hidden costs at the public must bear when facing legal problems, and including financial burdens, and sometimes drug-related cases dominated at the criminal justice system with the war on drugs approach rather than being health-based. And unfortunately, Indonesia lack comprehensive data on the costs borne by the public in accessing justice, meaning that ongoing legal reform are not fully evidence-based. And in this context, the cost of justice approach is relevant as it can uncover structural barriers while providing an analytical framework. So this is cost of justice approach or COG. COG approach is a multidisciplinary analytical framework to identify and calculating the various impact and costs arising from the criminal justice process, both direct and indirect. And this approach encompasses all cost component borne by the offender, victim, family, and the government and society. And by considering all these dimensions, this approach provides a more comprehensive picture of the burdens of the justice system, while also opening up space for the formulation policies that are more efficient, focused on the needs of the people. So this is our initial research, COG in drugs offenses, show that the drugs offenses facing the legal system in Indonesia bear various types of costs at nearly every stage of the legal process, from investigation until the correctional and rehabilitation. These costs include payment for detention cell, visitation permits, communication access, transportation, and even bribes to be transferred to rehabilitations. The costs range varies widely from 100 rupiah to more than 200 million. It's reflecting the inequality and potential exploitation with the system. And these findings emphasize the cost directly impact access to equal justice. Offenders also bear various others costs that directly impact their well-being. These costs include physical and reproductive health services, legal assistance, access to certain facilities, and etc. At the percentage varies across group, but they indicate the financial burden doesn't stop at the formal legal process. Rather, it continues in the form of basic needs that are often unmet by the state. Next. Yeah, offenders also face intangible economic impact after serving their sentence or undergoing rehabilitation due to drug-related cases. The barriers include personal factors such as shame, low self-confidence, or psychological condition, as well as rejection from external parties due to stigma or a criminal record. And the data show that the reintegration process remains of challenging. The burden, intangible costs, health impact of drug-related cases is not only in the legal aspect, but also affect and social and relationship of the offender. Some respondents experience disruptions in their education, such as dropout of school, taking academic leave, or having to transfer school. And more than 65% of respondents also reported social impact, ranging from strained family relationship and rejection to stigma as expressioner. And our findings also show that the offenders in drug-related cases not only face a legal process, but also mistreatment during detention on rehabilitation. The form of abuse experience include torture, sexual harassment, extortion, restriction on access to legal assistance, inadequate facility conditions such as improper foods and overcrowded cells. Yeah. All findings regarding the tangible and intangible costs experienced by offender in drug-related cases within framework of the cost of justice have been summarized in the available infographic booklet. This publication is expected to serve as a reference for all stakeholders in advocating for criminal justice reforms, and it can be accessed for free through that link. And next, my colleague Dio will be continue the presentation by explain how the cost of justice approach can be strategically utilized by international development partners to support the legal reform agenda in Indonesia.
Okay, thank you, Gladys. Maybe I will continue for the presentation. When I want to explain about why this matters, maybe I would like to describe about the background of the drug policy reform in Indonesia. Because in Indonesia, like some of policy actor about the drugs issue, like believing that criminal approach or the harsh punishment will be more effective as the deterrent effect to minimize the negative impact about the drugs trafficking in Indonesia. However, it's rarely to giving like the evidence what the cost or for the economic and the social impact about the harsh punishment policy in Indonesia. So that's why the cost of justice, it will become a fundamental issues in the criminal justice policy reform, because we can give like the evidence what the economic impact and the social impact about the loss of the for the people and about the impact of the drugs policy. And maybe like or Gladys already mentioned before, like in the drugs criminal crime in Indonesia, mostly the criminals is coming from the disaffected group from the social and economic. So that's why how the economic and the social impact will be effect after the marginalized group has to go to the criminal justice, and because there is like so many costs, even the formal costs and informal costs, like there is like a potential corruption or something like that. So that's why it will be like the giving like the more the inequality effect to the disaffected group for the Indonesian people, especially for the drugs user in Indonesia. And continue. So that's why the cost of justice matters in Indonesia, because like I mentioned before, it can like evidence-based evaluation for the frameworks, because like especially maybe from the because we are coming from the NGO's perspective. In the NGO, sometimes when we try to advocacy before, we never like giving like the empirical evidence. We just like giving like the normative issues about the drugs policy and why the criminal approach is not effective. So that's why for the discussion and the cost of justice can like giving like the to fill in gap about the how the evaluation based from the drugs policy in Indonesia. So that's why it can analyze how the effective and the efficiency for the criminal justice approach for the drugs issues in Indonesia. And next. So about the policy implication, like we also cite from Dominguez and Rafael, the policymaker can make a better decision to allocate resources more effectively and efficiently. So that's why for like Gladys already mentioned about the data, so the policymaker can understand about the impact if and from the social and economic perspective. So that's why when we try to understand is there any alternative approach about drugs issue in Indonesia, so that's why before analyzing the alternative approach, this can be like the of evidence to make it a better decision to allocate resources more, because like for the criminal justice approach in Indonesia, the Indonesian government already giving like the huge budget for legal officer and how to give for the jail or something like that. And so that's why after that we never saw the impact about that. Maybe we can also giving like the understanding about the Indonesia experience, because we already giving like the huge funding for the prison, for the legal officer, but criminal drugs crime always increasing in every year. So that's why when we mentioned about the deterrent effect, we never have the evidence about that. Even for the budget is always increasing, but the impact is like has the similarity effect based on the allocation budget of the Indonesian government. Next. However, there is still challenge about the policy implementation in Indonesia, because even we already like make it like the evidence based. I think for the Indonesian criminal justice actors, is also difficulties to translate from the data into like the what kind of the intervention policy. Especially for the NGOs who advocate this issue, we rarely to campaign to analyzing about from the data what the technical intervention policy. Even the Indonesian stakeholder for the law reform there is also difficulties for using like the empirical data or the calculating data into the translation into the kind of the law intervention after that. And then in Indonesia right now there is also like the challenge to meaningful participation in Indonesia. So that's why for the NGO, sometimes in Indonesia political situation now is sometimes the participation about the policy reform in Indonesia, there is like a criticism about that because maybe the government maybe already like make a room for the discussion, but about the participation, sometimes the problem for the criminal justice policy maybe, for example, like in the recent days, Indonesia just enacted the new criminal procedure law, but the problem there is like a critic from the NGO because like the process, even there is like a discussion between the government and NGO, but the government didn't giving like the didn't giving like the what their response about the input from the NGO. So that's why the participation is still has a problem for the criminal justice. So that's why when the NGO try to bring select the empirical evidence or the bottom up findings, even in the drugs policy, is because the sensitive issue, it will be more challenging to meaningful participation for the policy reform in Indonesia between KSO and the government. And then what the role of the international development partners, according to the experience for the AGRS, and even we interview the representative of donor. The donor is the initiate of this approach is coming from the donor, because when the donor has a discussion with the government, sometimes the donor needs also a challenging idea from the common approach in Indonesian policy right now. So that's why they need more evidence. So that's why they has the idea how to measure about the cost of the criminal policy approach. So that's why the donor and government can discuss what the alternative approach about this issue. So that's why after this idea is coming from the donor, and then the donor is also making effort to connecting the Indonesian government and the KSO for conducting case of justice research. So that's why what kind of role of development partners, like we mentioned here, is about the bringing the new idea and approach to the Indonesian government, and how to connect the Indonesian government and NGO to conducting research together and have a room for the discussion. And then continue. So that's why this is like the key message from us about our funding. Like, cost of justice approach can serve as a model for evaluating criminal justice policy, not only for drug-related crimes, especially the model. It can be applied maybe not only for the drugs crimes, but maybe in another issues, maybe like for another issue, like maybe in the legal aid policy or something like that. But when we want to emphasize about the cost of justice, Indonesia needs actors who adopt this approach in criminal policy making. So that's why the understanding about how to translating the evidence-based and the empirical finding from the calculation into the what kind of intervention is really important. And however, relationship between donor, NGO, and government is really important to introduce the alternative approach. So that's why, because the NGO is coming from the people, and they can bringing the findings from the bottom to the top of government. So that's why it's very it can help the government to understanding what the problem in the people or in the community. But it's also emphasized about the relationship should be like transparent and accountability, because like we mentioned before, there is like a challenging to the criminal reform approach in Indonesia, because like about the accountability from the response of the government about the participation in NGO. So this the NGO want to know what the feedback from their input, and even after the policy is already established, why the NGOs or the community or the people also questioning, but why they decide policy like that, because it will be different from the input of NGO. So that's why the transparency and accountability is really important. And then from our funding, we also found from the current criminal justice approach from drug issue, not only giving the burden of the cost of the government, but there is like the hidden cost identified beyond official law enforcement procedure, such as payment for rehabilitation to avoid prison or for cell replacement. So that's why the criminal justice approach and the harsh punishment is like giving like a more like potential corruption in Indonesia problem, and the effect will be more difficult because like the drug user is coming from the marginalized people from the economic and social background, and the challenge remains like we mentioned before, the translating data findings into actionable policy reform need like more understanding about this issue. Maybe this is like our presentation. Maybe we can continue for the Q&A sessions. Thank you very much.
Thank you so much, Dio and Gladys. I'm not sure if you could see, but that was a big round of applause from the audience behind the camera here in Canberra. We have 15 minutes for questions. And I actually have two to start with. So first for Desi, Marsha, Dio and Gladys, I'm really curious, hypothetically, if you imagine that you had the opportunity to design Australia's next justice program in Indonesia, what would be the end of program outcome and where would you begin to achieve it if you had that ability and that budget? And then I have a separate question for Arsa. Obviously, everyone that we've heard from today has had some affiliation with the Indonesia Judicial Research Society. It's clearly an impressive organization that's doing a lot of really important work. So I'm just really curious to hear a little bit more about sort of the hardest thing for an organization like that and maybe what you were most proud of during your time as director. Maybe I'll go to you first so that the others can think about their hypothetical programs.
It's a hard question as well because there's a lot of hard things, difficult things that we have to did in ensuring that the organizations still run through the correct outcome that we are planning since in the beginning of the formation of the organization, because the IGRS itself only established in 2019, 2018, yeah. So we are pretty young, pretty young organization, but we try to always do this research on a lot of new topics, a lot of new things, do the research that never been done before. That's one of our principle, because we understand that we cannot assume on, especially on the legal issues, because it's related to people's life. In Indonesia, there's a saying that you can go bankrupt if you are sick or you are dealing with legal problems. So as that saying goes, I think the hardest thing is that we have to develop a very rigorous tools, a very rigorous concepts to be researched on, because we cannot just do the research with a simple question on how is the experience of the justice seekers. That's it. No, we cannot do that. We have to do the development of the concept itself. We have to consult with a lot of communities as well, and we understand that there's a lot of needs as well in there. Not only the communities' needs, but also the needs of the funders, the needs of the government, the needs of other people that are interested in the research. So to maintain our independence, to maintain our accountability, I think is the hardest thing to do, and also the proudest thing that we kind of already achieved up until now, because even though we work together with a lot of governments, a lot of government funding as well, we try to deliver as much as true research as possible, because sometimes the government just got angry to us. Why is the results like this? It's not what we expected. Yeah, of course, if you expected this, you cannot. You don't have to do research. if you already know what your expectation is. So we always try to introduce a new, like what Gladys and Dio already presented as well about the cost of justice research. It's actually the very first cost of justice research in Indonesia. It's supported by DFAT as well. We consulted with the Australian Bureau of Statistics as well to conduct this very rigorous research to measure the cost of the justice when people trying to enter into the legal process. It's not about the payment of the lawyer, but it's also about how they lost their education, how they lost their jobs, how much it costs actually to encounter the legal problem. Like what they said is very expensive, like how much expensive. So this kind of thing that we keep trying to introduce to the not only the government, again to the donors, to the funders, and to the community as well, because we got help a lot from the community organizations, because we understand that they are the people who knows what's going on really in the community. So we conducted several like research training as well in the community in several areas in Indonesia, so they could like evaluate and monitor the things that happen in the community as well. So maybe that's the thing that very hard, difficult to do, but I think it's very a learning process for us as well to understand what are the needs of those many stakeholders together. So yeah, maybe that's all. Yeah.
Yeah, go for it. Whoever, Marsha. The hypothetical program that you would design, what's the intended outcome and where would you begin to achieve it?
Okay, so ideally it will be continuing the good practice that's been done, which is the evidence-based policies, because going from our experience with the regulation in the Supreme Court and the Attorney General Office is that even though they are like initially like, why should we do things like this? Why should we write it in the regulation that we should not blame women who are victims of sexual violence? Like they question that, why is this mandated? Like, but when we present a research, the interesting thing is that back in 2017, before the Supreme Court regulation, is that IRS alongside with the APIC Legal Aid conducted a research about the tendency of victim blaming that's been done by judges, and it was pretty high, and it affects how the judges rule the conviction for the offender, because when we find the findings that the judges said in the transcript, in the court transcript, is that this is what happens when you go out at night. This is what happens when you work at night. Things like this happen. Like it made the conviction for the offenders lower. So we see that how the judges, how they think affects the justice delivered to the victims. Like, so we delivered the research, we made it, and then we also found like champions in the court that said that also this is important to be told. So this is important to try to erase personal biases when we are dealing with victims. And what I see is that there is a hope in like evidence-based policy making, and we are presenting like actors who work in it, like the people in the legal aid, and then we also bring forward survivors who are willing to talk about the experience, and it changed the mindset of the judges and made the whole ordeal of the Supreme Court regulation more acceptable. So hypothetically, when we are talking about what's next, is that maybe we can undo the discriminative procedures in Indonesia, such as in the terms such as sexual health and reproductive health, because for now, a lot of the services in Indonesia are only intended for people who are married. But as we see in Indonesia, is that we have a very high and rising rates of cervical cancer, and it is because like for the pelvic exam, you have to be married to do that, so you cannot get early screening for that. Because technically you can do that, But often the doctors have their own biases inside and biases in their mindset, and that make people afraid to come forward. So hypothetically, for the output for that is that we can undo the discriminative laws when it comes to women accessing health. Maybe that's for me. Thank you.
Yeah, excellent answer. Continue the momentum of the Access to Justice partnership, but trialing those approaches in some new areas as well. Audience, also you're on notice if you've got questions ready, but we'll pass to Desi next.
Thank you so much. My name is Agus. I am from Remisi, and I'm here representing Transforming Communities for Inclusions. It's a global organization for persons with psychosocial disabilities and mad people. So congratulations on the presentations. I see Indonesia talks a lot about access to justice and gender-based violence. However, persons with psychosocial disability are still denied their legal capacities, their right to make decisions based on mental capacities, and face many forms of human rights violations such as forced sterilization, forced abortions, and deprivation of liberty. And the existing substitute decision-making guardianship frameworks in our mental health assessment to assess persons' legal capacity based on their mental capacity authorized by the mental health law, and it's supported with the new Supreme Court regulations. In this power dynamic systemic operations based on sanism, how are we addressing the legal capacity barrier faced by people with psychosocial and intellectual disabilities to ensure that our legal justice is inclusive and no one left behind? Thank you.
Who was your question for, sorry? Dio, it's been suggested that you might like to answer first. Otherwise, if anyone wants to jump in, please feel free.
Sorry, can you repeat the question? Yeah. No, sorry. But because I get like a bad connection.
No problem. We're just getting the mic to our friend in the audience.
Take two. Sorry, I think I'll just make it quick because in our legal justice systems, we still use the guardianship system, and we still use the mental capacity assessed by professional, and it will deny our legal capacity specifically for persons with psychosocial disabilities or intellectual disabilities to access justice. And my questions is regarding the existing substitute decision-making guardianship frameworks and mental health assessment that is discriminative to our rights in this power dynamics and systemic operations based on sanism. How are we address the legal capacity barriers faced by people with psychosocial and intellectual disabilities to make sure that our rights is equal by other people, because this barrier, it will lead to human rights violations such as institutionalizations, deprivation of liberty, including forced sterilization for women with psychosocial and intellectual disabilities. Thank you.
Okay. I think the question, I think it will be compatible if Marsha answer about that, because like it's about the access to justice in the court, in the court system. Yeah.
Fair enough, Theo. Marsha's volunteered to answer.
Okay, so I think we can begin by acknowledging that people with disabilities in Indonesia are often not represented in research and even the surveys about their well-being and what they need in the access to justice itself. Because I was involved in the surveys that Arsa mentioned. I was working on it too, and we also face like the difficulties of telling like governments like it is important to hear their voices. It is important to know their experiences, because most often they are faced with the most with the worst parts of being affected when you are in conflict with the law, or when you do not have a good guardianship, or when you are abused by your own guardian and family. And those are the things that are not seen. And the thing is that often that even researchers, even donors, even the government itself, is that the lack of perspective to acknowledge that is that something that we need to fix. Because when we see that when some regulations may not reflect the needs of the communities, we have to ask ourselves, did we do well enough to include them, to see their perspective, to like look beyond our biases towards people who are disabled psychosocially? And I think we can begin that by undoing certain standards that's been done for now, and then that we have to advocate and stand behind behind people who are disabled to ensure that their perspective are seen. And from my experience is that it is very difficult to get into it, because I also understand that there is a feel that when you are from a marginalized community is that you are only being used for data. What are we getting from that as people who are disabled, for example, or people who are underrepresented, or people who are queer, for example. And there is like a sense of like, I do not want to participate in such thing, because you only want our information, but we are not getting anything in return. We are not getting anything back for our community. So I think in a sense that we also have to build such relationship with the communities to make it trusted, and to make it like, this is a thing that we are working for a better future, let's say that. Because from my experience is that the lack of the connection and community might affect that too, whether you are from the civil society itself, from the government, or from the donors. So I think for short, my answer is that it takes a lot of perspective to do it, and acknowledge that we still have to learn, and we have to hear more from their voices. Maybe that's that's my answer.
Thank you, Marsha. Not an easy question. We have to stop there. But of course, if you have more questions, approach the panel, and another round of applause, I think, to these magnificent.